So if you are eligible for adjustment of status, let's say you're married to a U.S. citizen or you're a U.S. citizen married to a foreign national. First of all, you can apply for, the foreign national can apply for adjustment of status, which is just the technical term for getting permanent residence. If the foreign national was inspected, admitted, and paroled into the United States, or paroled, I should say, into the United States. So if someone snuck across the border, which we know people have done by the millions, they're not eligible to adjust here even if they are married to a U.S. citizen. So that's a major block. There's one old piece of law that people used to call the Clinton law. If paperwork had been filed for the person on or before April of 2001, they may be able to just pay a $1,000 fine and stay. But in most cases, people who are not inspected, admitted, or paroled are not going to be able to apply for permanent residence here by way of adjustment of status. The spouse of a U.S. citizen has a permanent resident number available immediately, and so does the spouse of the spouse of a citizen does. And starting August 1st, the spouse of a permanent resident does for, we estimate, 7 months. So that opens a window, because you have to have a number immediately available. It opens a window in 7 months, in a month, and it's going to last maybe for 7 months. Not true if you're married to a U.S. citizen. That's not going to collapse. The citizen spouse never has to worry about numbers. So the second preference category is that spouse of a permanent resident. And again, pay attention to that, or if you have friends who are talking about being married and they're both foreign nationals, if one is a resident, this is a very critical time to study whether or not they can sort of solve a problem. It's a major problem facing them. Now, if you are not married to a U.S. citizen and you are married to a permanent resident, it looks like you could file for adjustment because numbers are immediately available for the first time in years, but you can't apply for permanent residence if you're married to a resident and you overstayed your visa or worked without authority. You can only do it if you're married to a U.S. citizen. So they open the door and then quickly shut it on many people. Again, that needs to be studied carefully if you're planning this, so that you don't file for something that really exposes you to the government, and then they're going to slam the door on you and say you're not eligible for adjustment and we will put you into removal proceedings. If you're married to a citizen, they'll forgive unauthorized employment. They'll forgive overstay. If you're married to a resident, they won't. I don't need to go through this in too much detail. Where are we? Yeah. Okay. So there's, it's typical government stuff. Everything is done by forms. So you have to file a series of forms. If you go to uscis.gov and look up the forms, the form system that they have is actually quite friendly nowadays. Lots of good explanations. There's pages and pages of directions. It's that every line means something to them, though, so it's not just that the form appears simple, that it's readily available, and that there's good instructions. It's also that whatever you're filling in needs to be studied carefully to make sure it's not triggering another problem later on, and I'll mention a few of those afterwards. So the citizen files this I-130, it's a petition, and the foreign national files the I-485, the adjustment of status. Again, if it's a U.S. citizen, always they can go in together if you're filing for adjustment. If it's a permanent resident, in the past, the resident could only file the I-130, and the 485 had to be filed years later. So I'm just sort of hammering home that idea that there's an open window right now that hopefully will benefit some people, and in the future it won't. There's a bunch of supporting documents. The packets are usually quite thick. You've got to establish you're a U.S. citizen, that you are free to be married, that you are married, that you will support your spouse through certain requirements, and that the marriage is for love and not for the green card. And so that requires a whole lot of production of documents on the citizen side, and on the foreign national side, you have to show some of the same things, and you also have to show that even if you are married to a U.S. citizen, you're not otherwise prevented from getting a green card. And that process is not something applying just to us. This is the process that's been in use for probably 40 years or more at this point. More and more forms, but it's basically the same process. There's additional supporting documents, filing fees, etc. A couple of things. If you file for permanent residence, you can get employment authorization because of the filing, and on average it takes about 90 days to get it. If you file the form for that, which is the I-765, With the application for residence, the I-485, there's no fee for the 765. So you have to, if you file it concurrently, you save $380. Okay, so you want to do it. Even if you have employment authorization under some other category, it's advisable to file and get this. Whether you use it, if you have another category working for you, you need to work out with your own counselor. But it's something that you can get for free. You may need it, and so you ought to apply for it. The ability to travel while the application is pending, though, is much more complicated. If you file the I-131, you're filing for a travel document while the application is pending. Yeah, in the Boston area, the applications take on average 4 to 8 months, and usually more like 5 or 6. So it's not a super long period of time, and we don't think the numbers of same-sex couples filing are going to be so big that it's going to balloon out in a big way. It might, but it's not likely to. So you really have a period of, let's say, 5 to 6 months on average where you're stuck. If you don't have this travel document and you leave and you don't have an H or an L visa, you abandon the application, have to remain outside the United States, and now file in front of the American consular office. If you have the travel document, you don't abandon, and you are allowed to travel and come back. But there's a huge caveat here. If you've been in unlawful presence for more than 3 months, even with this travel document, if you leave, you face a 3-year bar to reentry. And if you've been in unlawful presence for a year, you face a 10-year bar to reentry. They may let you back in, but they will apply the bar to reentry when you have the sit-down interview with the immigration officer on the application. And you then have to file a waiver for that bar, and those waivers are very difficult to get. So that everybody, I think, I don't see any reason why everybody should not apply for an employment authorization, but whether you apply for advanced parole needs to be looked at carefully depending upon the facts. I'll end with this, but just in terms of timing. File with the lockbox for immigration. 2 weeks later, sometimes faster, we just got one in 4 days. They send you a receipt for your fees. 2 weeks after that on average, so about a month from filing, you'll get what they call a biometrics appointment where they fingerprint you and photograph you, and then they run FBI, CIA, Interpol security clearances on you. 2 months after that, so 3 months from filing, on average you will get the employment card, and if you're eligible, you'll get the advanced parole, which will again allow you to travel if you are eligible for it. And usually 2 to 3 months after that, you'll have an interview with an immigration officer in person. In Boston, most people are going to be going to the Kennedy Building. If you're north and a little west of the city, you go to a district office up in Lawrence. The interviews are only about a half hour generally. There's a mini fraud marriage interview at the beginning, but it really is mini. They only take usually 5 minutes or so, maybe 10. And then with the U.S. citizen, then they have the foreign national spouse come in. They don't separate them completely. So the interviews are really fairly straightforward, but they're loaded with technical stuff based off of every line on the forms. So, and I'll end with this. So I marry someone who is from Jamaica. I filed a petition for my spouse. He came here on a student. He overstayed. That's going to be forgiven. He worked without authority. That will be forgiven. Now they are going to look at him to decide whether or not there are otherwise reasons to deny him residence. Is there going to be something in his own life that, despite the fact that I'm a U.S. citizen and they believe we are in a valid marriage and they approve my petition, they will still deny? So they look at health issues. Used to include HIV as a horrible bar. That's gone. Criminal conduct, not always convictions, definitely convictions, but sometimes just the conduct alone. Certain political activities or membership. National security issues. Past immigration violations. So they're going to go over everything they have on you in their system, and then they're going to go through the form that asks you a lot of things about how you've handled your immigration past. And then economics, which is basically, are you likely to be a public charge? Are you likely to have to receive public benefits that you are not entitled to, because you would be entitled to some. If they find that some one of these apply to you, then they examine that in more detail. Some are minimal and it won't block you. Some are really definite blocks, but there might be waivers. And some, there's no way out. So you want to explore this before you file that application that seems rather straightforward, because if they get to the point on that application where they've got you on something that you didn't pay attention to, then all you've done through this whole process is expose yourself to them. And then they've got you. They can put you into a proceeding. Most people's cases, from what I've seen so far, the numbers we've seen, most people are eligible and they're not going to be troubled by this. But if you have any of these issues, you don't want to hide it from your partner, and you don't want to hide it if you have a lawyer from your lawyer. You want to get it out, because more than likely you and the immigration officer are going to know about it. And you don't want to end up having that situation where you've been unprepared, your advocate hasn't been able to help you out, or maybe simply say to you, don't file. So this is the whole process. This is, it seems almost magical to me, after having told people for 35 years you can't do this, that we can do it now, and it's a moment to celebrate. Yeah.